Thank you, Toby and Keon. And thank you, everyone, for being here. My first experience with arbitration was about 15 years back. Our firm had gotten not that significant a case, and it related to a local arbitration. So in our lunchroom, we have a lunchroom session almost every day, which lasts for an hour, which is mainly gossip, a bit of politics, and sometimes some discussion on law and legal aspects or affairs that we are facing. So I raised this issue before the senior people sitting there, and I asked them that I've read that the arbitration is all about speedy justice and it is supposed to be expeditious and all. Do I need to be worried? We are the defendants. So two of the senior most lawyers sitting there, they just laughed it off and they said, a typical civil court case will take between 10 to 15 years. Think of arbitration as two civil cases. So in the first round, you'll start from the civil court, you'll go all the way up to the Supreme Court and figure out who is supposed to be the arbitrator, what is the scope of the reference, and all the technical things. And in the second round, once you're done with the arbitration, then you can deal with the merits. So don't worry about it. Now, this is 15 years ago. And I must say, the experience that I've had, luckily, has given me a lot of positives and a lot of optimism as we speak today. So we have here Mr. Ahmed Hussain also, and in the last 2 years, we've been fighting over an award where one of the central points was whether an arbitral award is a piece of paper to be thrown in a dustbin or not. So we have all of these issues in Pakistan, but what I wanted to share was the positive developments that we've made, and we've made a lot of them, especially in the last 5 to 7 years. And I start with the topic that we have, which is pro-enforcement. So where do we stand compared to, for example, what I was told as a young lawyer 15 years back? Now today, we have the 2011 Act, which yes, deals with international arbitration, but it sets the tone for a lot of things that have to do with arbitration. And we have the New York Convention, which has been incorporated in our law under the 2011 Act. And in the last 5-6 years, we've had a series of judgments from all the high courts in Pakistan, and mainly because here we are sitting in Lahore, we have at least 4 or 5 judgments from the Lahore High Court where the arbitration awards have been, number one, enforced. It has been done relatively quickly, even compared to international standards. And we are at a stage now that if, as a lawyer, somebody approaches me and tells me that there is an arbitration award, it's a foreign award, and it is against me, then I would not be as comfortable as my senior colleagues. I would really think that there is a serious issue at hand. So starting especially from, so we had the law of arbitration dealing with the foreign awards enacted in 2005, initially as an ordinance, and then we have the Act of the 2011 Act. And under that Act, starting from 2016 onwards, we have got judgment after judgment, the most recent being from Mr. Justice Jawad Hassan here, where they've started enforcing the awards. And the good thing that we are seeing is that the principles and the framework that is being laid down, we can very confidently say it is pro-arbitration, it is aligned with how things are being looked at internationally, and we have at least one case, which is Orient, which has gone all the way up to the Supreme Court, where the Supreme Court has held that we have to look at the convention issues and do it uniformly. So on that front, I think there is a lot of optimism, and even from last conference till now, if people see, there's been a lot of improvement. But what I wanted to touch upon is another aspect, This is the good side. We still have problems. And amongst the problems that we have, I think it's a more Pakistani law issue than anything else. It doesn't arise out of the New York Convention. And for those, and we have members of the judiciary here and as well as lawyers, and anyone who's ever dealt with the 2011 Act, the capital C and the small c problem is something that is known to everyone. And that is something which I very quickly want to highlight, because when we talk about a pro-arbitration or a pro-enforcement aspect, yes, one part is the award. And so far as the award is concerned, I think we are moving forward in a very good direction. But then there is another feature, which is the pre-award. So we have at least two stages. One is the pre-arbitration stage, and one is the stage when the arbitration is ongoing. And in that respect, I think we are still faced with problems. Because if arbitration is going to happen effectively, smoothly, and quickly, it is important that there is clarity for lawyers and also for clients. Where do they stand in terms of their options? And anyone who wants to undermine or obstruct an arbitration, which at least in my limited experience, at least one, usually there's always one party in an arbitration dispute who wants to run away from that dispute. And in our existing system, we have that problem in the law, where even after at least 15 years of this law being there, we are still not clear, at least as lawyers, which is the correct forum. Is it the civil court or is it the high court? And that's a problem which I think has conveniently been thrown at the table of the judges, because the law itself has those confusions. And as I speak today, we have at least a few judgments, and we can read those judgments and we can have further arguments on that, but it reflects the confusion in the law, where we have judgments from at least 3 high courts. The most recent one again being, so for example, the most recent judgment we've had from Justice Jawad Hassan, we have the exclusive jurisdiction of the High Court, which makes it very easy for an arbitration practitioner who wants to work towards pro-enforcement. But at the same time, given the difficulties with how the Act is structured, we have other judgments where that distinction is also there, that in some matters, you can still go to the civil court and have part of the dispute that may be somehow linked to the arbitration matter sorted out in civil court. And this fight over forums is something that holds back an effective dispute resolution. So just to sum it up, there are 3 real issues that are being faced by lawyers, and obviously those disputes then come to the court with their problems. The issue of a party that wants to run away from an arbitration clause and the ease with which they can approach a civil court and get some kind of a stay order. So for example, in 2 of the recent judgments that we have, there have been injunctions against a party, and in one case, because it was a foreign party, they don't care about the injunction because they're not worried about the contempt of court. But we've had cases where the party that wanted the arbitration was a Pakistani party. So if you have a civil court injunction against you, and if you are exposed to contempt, those are then very serious issues for the conduct of the arbitration. And in one case, at least, we even saw a foreign arbitrator staying his hands from the arbitration because he did not want to get into all of those troubles. The other issue that is equally important is the issue of conservatory measures. So again, if a client comes to me today, and a lot of times initiating the international arbitration is time consuming and you want conservatory measures, you don't know. So we've tried both. At times we've succeeded in the civil court, and at times we've gotten stuck in the high court because months pass on real issues of dispute on what is the correct forum. So luckily, we do have some judgments now, and there is movement forward. But what I think is that from a really practical point of view, this issue has to be focused on both sides, not just the enforcement aspect. as I said, we've made a lot of progress there, but on all aspects which are pre-award, those are areas where there's still a lot of confusion. Either we work at the policy level, rules can be made under the Act, or there are issues that will come before the judges. It still hasn't gone to a division bench or the Supreme Court, but those are the real issues that we have. And other than that, there were things I have in mind on the issue of Pakistan being a regional seat. Maybe there are others who will be talking about it. I just say two things on that, and probably it can come up with the questions. I'll be candid and honest in terms of a regional seat, and I'd actually would like Toby to say something on this. What are the expectations from a regional seat? I think we should be realistic and honest. I think we are far away from presenting Pakistan as a regional seat as things stand. We should dream about it, and only then will we get there. But I think we should be more focused on what is it that we can do to get there. And I think the first step we are already doing, which is making the international arbitration an effective mechanism of resolution. I think we are already making progress there. So far as domestic arbitration is concerned, I think we've not moved much from where we stood 15 years back. As a lawyer, I'm very concerned if I have a case before any of the judges and it's a foreign arbitral award. If it's a local arbitration award, I'm not bothered at all. I know it will take its sweet time. So these are the two key areas I believe we need to focus on, and taking guidance and inspiration from what we are doing in the 2011 Act framework. And if we can make that as a base and then continue with that, first to make local arbitration as something which has integrity, which has competent people, and which actually starts delivering results by way of effective and expeditious resolution of disputes. Once we've achieved that, I think that is the time then we can seriously start thinking about Pakistan being a regional seat of arbitration. So that's all I have for now, and then we'll see how it progresses.